Hey everybody, welcome back. We are excited for our next session. Before we launch into that, I just want to remind you, as Corey mentioned this morning, if you haven't downloaded the mobile app, make sure you do. We do really appreciate, especially your session feedback. So when you get into the mobile app, you can go to any of the sessions, scroll all the way to the bottom, and you'll find session survey. Give us your feedback. If you also provide your email address, we will enter you into a drawing for one of 2 Amazon gift cards that we're going to be giving away. I promise we won't use your email address for anything else, but give us your email address throughout the day when you give us your session feedback, and we will enter you into that drawing. Again, the sessions today, this morning, this afternoon, tomorrow morning and afternoon, make sure you give us your feedback. We appreciate that very much. You know, it's hard to open a website or to turn on the news. I used to be able to say it's hard to open a newspaper, but you can't say that anymore, without finding a story about a mortgage lender or a personal loan processor or a for-profit college. We all see it, but it doesn't just affect our industry. There's a lot of news going on, but it affects millions of people around the United States. And so we're very excited to talk to somebody representing a legal mind, somebody representing state and federal regulators, and then somebody representing the industry to really talk about the legal landscape, the regulatory landscape right now. I'm very pleased to introduce Jonathan, Joy, Elizabeth, and Marty, and I'm going to let them take it from here. So please give them a big round of applause.
Warren, thank you. And thank you, everybody. Good morning. Today's panel, Lead Generation, Legal Responsibility and Accountability, a sit-down conversation with federal and state regulators, is intended to be a terrific overview of the legal and regulatory landscape that's evolved in the last several years here in the United States for online marketing. The reality is that the landscape has changed significantly over the years in ways that have been demonstrable, both from an operational standpoint as well as also from the bottom line standpoint. But before we get started, today's speakers, of course, are simply giving their views. We have representatives of the New York State Department of Financial Services, we have a representative of the Federal Trade Commission, and then we also have a member of industry. And each of them are expressing their viewpoints only and not of their agency or of their company. So, without further ado, first off, we've got Joy Feigenbaum from the New York State Department of Financial Services, Liz Kwok from the FTC, Federal Trade Commission, and Marty Collins from QuinStreet. Now, lead generation has rapidly expanded. The market for online sales is astronomical. But what has happened in the last several years is increased federal and state regulatory scrutiny. Whether it's a specific vertical or a particular marketing method, the federal and state regulators and the laws around that have evolved. And today's conversation is intended to talk about both opportunities and risks related to lead generation and the regulatory landscape. Now, without further ado, let's start off first with Joy. Joy, you're from the New York State Department of Financial Services, right here in New York City. Tell us a little bit about the New York State Department of Financial Services and your role in enforcement.
Sure. The New York Department of Financial Services was formed in 2011 by the merger of the former New York State Banking and Insurance Departments, and the law that created the agency, the Financial Services Law, provided for a single superintendent of financial services, now Superintendent Vullo, and it also created the Financial Fraud and Consumer Protection Division, which I lead, and we refer to it as FFCPD for short. The FFCPD has civil investigations and enforcement unit, a criminal investigations unit, a consumer complaint handling unit, and a number of other business units. We've got authority to regulate and bring enforcement actions against our licensees, whether it's insurance companies, our state-chartered banks, licensed lenders, money transmitters, check cashers, and other licensed individuals. But we also have authority, what we refer to as our Gaap Authority, over individuals and entities that are not licensed by the department, where they may violate laws that New York, that the department actually enforces. And so we have, in this space, we have pursued misrepresentations in advertising, by the lead generation industry in particular, and the limits on our authority are simply where there's a federal agency that exclusively regulates the financial product or service, or where we're preempted by federal law, or where there's another state agency that regulates for purposes of consumer or investor protection.
Liz, at the Federal Trade Commission, the jurisdiction and focus is slightly different, although somewhat similar. How does the role of the FTC compare to the DFS?
So the role at the Federal Trade Commission is quite broad. We have what is called the Federal Trade Commission Act, and the most common term you'll hear is Section 5, which provides us with enforcement authority against any unfair or deceptive practices, which applies quite broadly, as you can imagine, with the exception of any specifically exempt entities such as banks or nonprofits. And so in my division, which is the Division of Financial Practices, we're looking specifically at financial technologies such as peer-to-peer payment systems, or going over to mortgage and auto lending, and debt buyers, debt brokers, as well as payday lending, and just kind of anything that can fit in that umbrella. But we don't really have a limitation outside of anything that is not unfair or deceptive.
Marty, last year at this time, you were in the audience watching a panel on self-regulation and lead generation, ways for the industry to overcome, meet, exceed expectations from state regulators. But your role at QuinStreet as general counsel is both a compliance role as well as an advisory role to the business. How does that match up with what you're hearing here and what we're going to be talking about today?
Well, what Joy and her colleagues and Liz and her colleagues do is what we call at work required reading. Because we have verticals across financial products, education, and otherwise. And much of the work we do is multi-match. So in a sense, what the states do, what the federal government does, kind of becomes our minimum standard for people on our network and people that we're selling traffic to.
Now, last year at this time, we were previewing what was going to be, and did occur, the Federal Trade Commission's workshop on lead generation. Liz, that workshop was the culmination of many years of FTC and other scrutiny from state and federal agencies of the lead generation marketing space. Clearly, there had been activities that had been observed that gave rise to the need for the workshop, which was really an effort to aggregate quite a lot of information about the lead generation space. Tell us a little bit about the workshop, and actually, more importantly, what's happened since the workshop?
Well, that's a very involved question. So what the workshop itself was, we tend to host these workshops as we see a particular industry growing that might be subject to FTC scrutiny. We really like to bring together multiple stakeholders across industry, academia, and regulation so that we can really talk about what's happening in the industry and talk about best practices, any red flags that folks are seeing. And without obviously giving specific guidance, we do like to stay involved and just kind of give people an idea of a way to maintain compliance. So this workshop, as you can see on the slide, really talked about several key areas, which are, the opacity of the industry. Do consumers know what is happening with the information that they provide when they go to that web form and apply, for example, a payday lead? And then, of course, data security is another big issue. Once you have this data, how well are you securing it? And you are responsible if you have that data and it gets erroneously provided to someone, or in some instances inappropriately provided. You are still responsible, even if you were not necessarily the front line interacting with the consumer.
Now, Liz, has the focus also been enforcement, or is it just gathering information? Clearly, there's been some notable enforcement activity too.
Yes, we've certainly, you know, I have to keep my job, so we've got to certainly do some enforcement work. And there's been several cases in different areas. You know, we've done a case in the education area where there involved somebody who hosted a website that appeared to be providing jobs in education to the applicants, but really you were sent through a screening process that asked you several leading questions about your interest in furthering your education, and then there was never actually any job that you were applying to. You were just sold, your information was sold as a lead to be advertised to for-profit education. And then we've done several other cases that have involved one in the phantom debt collection arena where we had somebody who housed all the data and then sold it to someone who they knew was not a lender, and those people were either blind billed or in other ways charged without their consent or knowledge. And then we are also, you know, doing cases that involve just lead brokerage. So, like I said, what do you do once you have this data? Who are you selling it to? How are you securing it?
Now, Joy, the work at DFS is a little different because you have a licensee base. You have the ability to supervise organizations, companies, as well as also to license them in different verticals, which is different than the Federal Trade Commission, which ostensibly has its enforcement powers and then the bully pulpit education and information gathering tools. How does your work at DFS compare, and what are the activities that you've been involved in recently related to lead generation?
Okay. So we do have licensing status over our institutions and a number of individuals as well. But what was added with the financial services law was this additional Gaap Authority that allows us to regulate, you know, issue rules as we did recently in the debt collection area, where we don't license debt collectors, but we did, you know, issue rules as to how they should conduct themselves in New York. We also have enforcement authority over individuals and entities that are not licensed, where they may violate the laws that we enforce. So in the lead generation space, the bulk of our work in there has been in the enforcement area, and lead generators generally are not licensed entities with the department, although if a lead generator is actually making payday, you're not only selling leads for payday loans, but also making payday loans between 16 and 25%, which are within our usury caps, then they need a licensed lender license, and lead generators that solicit mortgage loans have to be registered mortgage brokers with the department. But the work that we've done in FFCPD has been enforcement, and we had 2 enforcement actions, one last year with Blue Global and their CEO, Chris KK, for payday lead generation, where they were marketing illegal payday loans in New York. Payday loans do not comply with New York law because their interest rates far exceed New York's usury caps. Civil is 16% and criminal is 25%. And we also had an enforcement action the prior year with Money Mutual and Montel Williams, who was the celebrity endorser for, for that product. More recently, going back to Blue Global, our focus was on the marketing of illegal products, but also claims on Blue Global's websites about the security that would be afforded the consumer's data when they entered the data via the Blue Global websites, when in fact the company had not vetted the lead buyers and other, lead aggregators to whom they were selling the information, nor were there any controls over what happened to the consumer's information. And the result of that was that many consumers received multiple calls from companies marketing all kinds of goods, and unfortunately many received calls from scammers that whether they threaten them, but, that obtained money, debited their bank accounts without their authorization. So they suffered a number of harms as a result of the lack of controls on the data security.
So the common themes already today, the data security, and then also just simply compliance with the law, the vetting of the front end and the back end in terms of where the lead is coming from as well as where the lead is going. Marty, keeping up with all of this is no easy task, whether you're an outside counsel like myself or in-house like you with a complete team of compliance and lawyers to keep everybody honest. The intersection of law and advertising is not easy. How do you keep up with all this?
Well, I don't know. I'd probably respectfully disagree. I think it's maybe it's simple, but it's not easy, right? I mean, the reason you come to panels is you listen and say, 80% of that I knew that, right? And so I would think that 80% of the people here understand that, as Liz and Joy pointed out, that there's a responsibility for context when you're gathering consumer data. And I would bet 80% of the people here understand that when you transfer consumer data to people, you should probably have some understanding of who they are and what they're going to do with it. If that's news for anybody here, I'd be surprised. I think the not easy part of it is how you maintain that on a day-to-day basis. I mean, it's online, it's a network, and any network just has, I know you don't like me to say this, Jonathan, but networks have a concept of availability. I mean, you're not going to have 100% compliance on any network, whether it's your computer network, your cell phone network, or your consumer data network. The discussion of hacking, when the NSA can be hacked, I guess we're all somewhat vulnerable, which is not an excuse, but it's to say that, with the slide that you have up, it's just one way we think about it. If we're marketing a product that's licensed in the state of New York, that's a compliance rule for us. Not being misleading is a compliance rule across all the verticals, right? And so you put those compliance rules in the machine and you vet people when they come on the network and you monitor that network every day with a combination of people and technology and contracts. And those contracts, you can't shift to other people the responsibility to be compliant. You actually have effectively an affirmative duty to monitor that. So that takes, it takes technology, it takes scale. We're fortunate because, again, we're multi-vertical, so we can take lessons learned in, say, education and run those in financial services, and we can scale the cost and our own tech development across those verticals as well. So I think, I think it's hard for individual clients sometimes to run compliance. For us, it's a little bit easier because, again, we're doing it across the multiple networks and just taking lessons learned and running them across the organization.
Liz, at the FTC, a lot of the enforcement work is driven by consumer complaints. When the commission is looking at bringing either investigations or law enforcement action, it's not just solely consumer complaints, though. What else factors into the mix?
Yeah, that's right. So consumer complaints are always an important starting point for us because, our main objective is to look out for consumers as a whole group. However, especially in a lead generation example, consumers don't know who it is that's causing them to be inappropriate billed or get phone calls from, all sorts of businesses that they've never personally reached out to themselves. And so what we do at the commission is we have several tools that we can use to really keep an eye on what's happening. We read the press just like everyone else. We do our own kind of research into the market, and we really just try to keep our ears and eyes open so that we can see where there are some trends happening. And really the number of complaints is not the driving force for us. It could be as small as one complaint that really alerts the commission to, hey, this sounds like this could be a problem. Let's see if it's pervasive or if it's a one-off and that kind of thing. And so we try to, we keep our ears and eyes open, as I said.
Now, Joy, in the supervised consumer financial services spaces that the DFS regulates, vendor management and due diligence compliance is a very big mantra. It's also a big mantra of the Consumer Financial Protection Bureau. know your neighbor, know your buyer, know your seller. How has the work of the CFPB impacted the work of DFS? Has it informed priorities? Is it changing what you see in the marketplace? How is that factored in now that the CFPB has been around for 5 years? DFS, obviously, its predecessor agencies had been around for a long time, regulating each of those consumer financial services markets. So there's a lot of overlap, but how does that all work?
Well, there is a lot of overlap, and when we were formed, we actually, in forming FFCPD, in a way, we were setting up a sort of mini CFPB in New York, if you will. So there's a lot of similarities in our work. We are wonderful colleagues and collaborators. We're co-plaintiffs in litigation together. As we collaborate as well with the FTC, we actually have access to complaints of New Yorkers through both the FTC as well as the CFPB, in addition to the complaints that are filed with us, so that we get a good sense of what's happening in the marketplace, and then we follow similar techniques to the FTC and our colleagues in the CFPB on sort of taking a broad view of a market and trying to monitor what's happening generally, particularly as Elizabeth pointed out, the consumer doesn't necessarily know that their information has been compromised with a particular lead generator. So we're looking at the kinds of complaints, and then we look at the industry generally and focus on what's being advertised.
Now, one of the big focuses lately with vendor management has been on the affiliate marketing side. So where the lead is coming from, if you're from an aggregator's perspective. So there may be websites, there may be other list management services, ways that leads kind of matriculate through the system from a consumer inquiry up the chain. But then recently, the Federal Consumer Financial Protection Bureau brought a lawsuit against a lead generator, not just for practices alleged related to how the lead was developed, but also to where the lead is going. And in that case, the issue there was it was a payday lead aggregator, payday loan lead aggregator, where the lead was allegedly going to a lender or lenders that were unlicensed and out of compliance. Now that's very similar, Joy, to the work that you've done already on the enforcement side in New York. Is that something that you could see mapping to other verticals too, or is that unique to payday lending?
No, I don't think it's unique to payday lending at all. Generally, lead generators are connecting consumers with some type of product or service. Our focus is in the financial product and service space, and that need not be whether that's whether it's student lending or a debt consolidation product or a payday loan. I think the lessons are the same, that we have the concept on the banking side, know your customer, with licensees, but here I think we really think lead generators need to have, bear in mind, know your lead buyer, whether it's an aggregator or, but they really, it would behoove them to really learn, to learn more about the companies to whom they're selling consumers' personal information and where that information is ultimately going to go. Because ultimately, under our laws and laws that our federal counterparts enforce, even though you're not providing the financial product or service, at the end of the day, you can be accountable through your advertising.
Marty?
So again, you have to know the context in which information was gathered, and you have to know where it's going. I think one of the challenges is against which database do I check, right? When the New York Times, somebody mentioned they still print the newspaper. When the New York Times runs an ad for Citibank on page 2 for a mortgage product, right? You don't know a priori whether somebody's picking that up in Loveland, Colorado, or the Upper East Side, right? So you don't really know, Citibank can't know, the New York Times certainly cannot know who's gonna read that ad. So I think it's hard, in mortgage lending, you can check a database which has all the people, the NMLS, right? And that was a result of a crisis. I'm not sure which database I go to check on, say, marketplace lenders, right? I'm not saying that you have to give me a database before I can do my job, but it's to saddle the Times or the TV or the QuinStreet with kind of an affirmative duty to know the license status of every purveyor of stuff on the internet it's hard. It's a challenge. And we generally prohibit the resale of information, so it's not a case where we're not going to know who that node is. But knowing if that node is fully licensed to offer that product and service to, remember on the internet, nobody knows if you're a dog. It's kind of hard to acquit that responsibility sometimes.
Well, I recognize it's hard. I also, if you're marketing on the internet or if you're marketing in national media, you can assume that the product is accessible
Yep.
to people in the state of New York and in states across the country. And so to the extent you're, for example, in the payday loan space, if you're selling leads for payday loans, you need to know the lay of the land. Payday loans are legal in 35 states. They're not in the others. And so that's, the onus is on the marketer
Right.
to have that kind of information.
That's actually why we don't do payday loans. It's just too hard. I guess Google doesn't do it anymore either. They just decided.
Right, but I understand, your position about having a database is, certainly a helpful tool, but where there isn't one available, then research. We found in the Blue Global context that there were scammers who actually had track records of buying leads and using the information for illicit purposes. And, in this case, Blue Global had shared consumers' information with those scammers. So a little bit of research on the front end can avoid, enforcement, on the back end.
Well, I can tell you, go ahead, Liz.
Sorry, and I was going to say, I think, it's not very common that we're looking to hold at either level of regulation, the New York Times or whomever responsible for the distribution. It's the content of the ad. Like you said, it's all about context and making sure that whatever is displayed in that ad is not deceptive or misleading in any way. And I think that that's, as you pointed out, a fairly commonly understood principle. And sometimes, when you get into certain verticals, can be harder when you're talking about interest rates and things like that. But that's what matters. It's the content of the ad. It's what you do with that data. It's more, once you've advertised across the country and have all these people coming to your website or, wherever, and they've handed over your data, then it's really your responsibility. You can control who you sell it to, who has access to your portal and your database. And I think that's what the emphasis from the regulatory side is, because, I think it's commonly understood that, you can't control anybody who can read that ad or, gets forwarded an email or something like that.
Well, let's talk a little bit about data security and privacy, because it's a theme that's come up already today a couple times. It was certainly a theme in the FTC workshop on lead generation, and it's been permeating really all the agency guidance, both agencies' guidance and other agencies for several years, but it's really hit a crescendo where you've got a number of enforcement actions that have been public against companies, in part related to data security issues, in part just related to representations about data security. Liz, what's the latest from the FTC's perspective? There's been some litigation involving claims, companies that have made claims that they were using a certain standard of security and protection, but apparently allegedly not following through.
Sure. So, our stance is always the same, which is you need to be clear with consumers about what what they're signing up for and what is happening with their data. And as you said, we've litigated a case where somebody said that they were using essentially kind of a bank level grade security. And similar to what Joy had talked about in her case, they weren't really doing any of it. They were kind of just copying and pasting from another more commonly reputable website and just pasting it, on their own, essentially. And so from the FTC's perspective, what we're looking for, and as was a big theme at the workshop last fall, is consumers need to be aware of what's happening with their data downstream. Not only should they have a clear representation of what you're signing up for. For example, if I'm coming here to apply for a job, I should really just be giving you my information to apply for a job, not getting marketed for-profit education. But how are you storing this? How long are you going to keep it? Where is it being stored? Who gets access to it? Do you resell at all? All of those things should be information that's readily accessible to the consumer and not necessarily, behind an asterisk, behind 6 more clicks, if you know which tabs to choose. I think that's the current perspective. And I think that is a theme that will carry through, particularly as consumers these days are faced with the choice of handing over a little bit of information for, convenience, and, certainly there's merit in that. But then, as Joy has said, the onus is on the person who takes that data. You really have to protect it. It's valuable, and particularly as we move more and more online, your data increases in value.
So the days of a lead aggregator saying, not my problem with respect to data security and privacy, if they ever were the case, long gone at this point.
I would say that's true.
Joy, you're seeing that in enforcement work too, and then on the supervision side, DFS gets involved with its licensees, reviewing those practices too.
Certainly, and where the department is proposing cybersecurity rules that focus on making sure that your third-party vendors care for the information and take appropriate steps with the information. And our settlement with Blue Global was very much modeled on the data security provisions, was very much modeled on what we're doing on the supervisory side. In Blue Global, the company has to stop, has agreed to stop and has stopped marketing payday loans in New York, but should they enter the market again to sell lawful products in New York, then we put a series of data security protocols that they would need to comply with, both the company and the CEO himself. So one thing I do want to mention, that we do focus on individual accountability as well as the company, but we have a set of data security protocols with provisions in contracts with third parties and periodic training and having a person designated as the compliance officer. So I would recommend to the audience to take a look at those, because I think, as you're pointing out, the days I think are gone where the industry can say, I'm just selling the leads, so I don't really have to concern myself with what's happening downstream.
Let's transition to some big picture lessons, some practical tips, guidance that folks can use to meet the expectations of the regulators. There's no silver bullet, there's no one size fits all, but Liz, from your years at the FTC, and then certainly the FTC's years at looking at online and not online marketing, because certainly a lot of lead generation also takes place by telephone, including in some cases in person. What are some good practices that were observed and discussed, and particularly at the FTC workshop?
Well, again, I think, it's all about how you market in the first place. So what are you telling the consumer they're signing up for? What is their understanding of why they're providing such sensitive data? And then once you go down to the kind of what you do after you have that information, it's really about having good security practices in place and vetting who's on your network. And like they've both pointed out, a little bit of research on the front end. Is it even smart to be wading into these particular states or this particular vertical? And we always say at the FTC, it's really just be clear with consumers, and you'll avoid a lot of the enforcement troubles later on.
Joy?
Certainly focus on your statements and advertising on consumer-facing websites. Again, websites, anything on the internet is accessible to New Yorkers, accessible to consumers in states across the country. So know that you're subject to the laws of those states, in our case in New York. In particular, we've been very focused on advertising on the legal status of financial products or services. In our case with Money Mutual, Selling Source, they kept making claims about the trustworthiness of the loans and the payday networks that they were marketing to. At the same time, they were selling, they were selling consumers leads to companies that were offering illegal products. So that's an advertising claim that you should be focused on. Also, we talked about claims about the security of information collected on the website. Don't give consumers false assurances don't overpromise the security of the data on your site, because you're collecting a lot of very sensitive information, and consumers, if they believe that they will, that the information is secure, they provide bank accounts, social security numbers, and that can have really significant harm down the road if you really can't ultimately protect that information. So consumers shouldn't be encouraged to buy false claims about the security of the information.
Marty, you work for a company that wants to make money, but
And does.
But you're in a role where sometimes you have to say, wait, we have to do it this way instead of that way. This is not all that easy. What are the next steps, that not just as a company, but as an industry, when you look at this, from your perspective of somebody who's looking at the regulatory environment and advising a business? Again, no silver bullets, but what does the industry as a whole need to do to address these issues?
Well, I mean, a couple things. What's something that somebody could do today? If the folks from Blue Global are here, they have a 10-page checklist about that takes care of vetting. I think our data privacy checklist is better, but if you're already doing business with us, you've already seen that. So I mean, I think they're quite proud of it. I mean, I think they have a new general counsel now, and I think she's the author of that work. So if you want to know what you're supposed to be doing based on the content that you're hearing, they might even volunteer it, because it's just kind of codified common sense. And it's a pretty good checklist to see if you're doing the right things. From an industry perspective, I've only been in this business for about 2 years. I find it it's interesting that there's no babysitter. There's enforcement activity, and the difficulty with enforcement activity is, sometimes bad facts can make interesting laws, but it shouldn't fall to the FTC or New York State or state attorneys general to be supervising. So it just seems to be a huge gap between companies like ours that are trying to, maintain network compliance, and then the next stop is, Washington, D.C. or New York. So I guess I'm surprised that there hasn't been self-regulation in this industry the way that there has been in numerous other industries, especially when you're selling stuff on the line. And I know it's a little bit, I mean, maybe the kids have gotten used to not having a babysitter around, and no one really wants to have a babysitter once you've gotten used to just kind of running around the house. But I find it's interesting that it hasn't, probably hard to mandate. It's interesting that there's no supervision really between the company level and then, headquarters.
Liz, the FTC workshop on lead generation has aggregated a lot of different viewpoints, a lot of different information. There was already a workshop on fintech and marketplace lending.
That's right.
There's going to be one in a couple weeks on consumer disclosures and the effectiveness, and then another one on peer-to-peer lending as part of this fintech panel. So no shortage of sort of information gathering. But in the experience of, from an advertising perspective, what works and what doesn't work for industries as a whole if they want to demonstrate to, say, the commission or to individual investigators such as yourself, that they get it, that they before the CID, the civil investigative demand or subpoena, comes through the door, before a knock on the door, how does somebody show, we're compliant?
Well, certainly it helps when you don't have a website that has tons of fine print on it, buried beneath lots and lots of clicks. As Marty has pointed out, when you have a clear checklist, and from the consumer perspective, certain companies are really good about having a very clear frequently asked questions section that says, what happens to your data after you enter it today? Or as Joy said, don't have tons of representations that you can't back up about the level of security that you have on there. And really, I think, as Marty has said many times, it's a common sense principle. You, as the industry side, can also go to that website and sit there and read it, and can you get multiple understandings from it? If so, you're probably heading more into the confusing territory rather than the clear and conspicuous category. And as you've said, there's really no silver bullet, and I certainly can't provide you a list of how you can format your website to avoid ever hearing from someone like myself. But we really just push being very clear with the consumer, having readily accessible, frequently asked questions that really answer the common questions, and then, again, having your terms up front. Depending on which vertical you are, that's very important. You can't hide the kind of fees that they're going to look at or the kind of interest rates that they could be facing. And so what we look at from the FTC's perspective is just really how upfront are you with the consumer, and how easy is it for the consumer to ask questions, get in touch with you, and things like that.
Isn't there, what's the FTC thing coming up later next month on, isn't there a disclosure one?
Yeah, he did bring that up, that there is a FTC panel workshop on disclosures, yeah.
And a lot of guidance too, FTC.com disclosures guidance, and obviously no shortage of enforcement examples where in some cases disclosures may not have been enough.
Yeah, we certainly do not hide the work that we do. We try to have a pretty robust business section where you can go for some of our business guides and other things like that. And with every case, we always maintain a site that has the press release, the court papers, and other relevant, if we do associated blogs and things like that. We try to be very forthcoming and open about the things that we're doing.
Joy, at DFS, what's on the horizon?
Well, the superintendent is still very focused on an honest marketplace for financial products and services in New York. So we are continuing to focus on whether they're predatory, abusive products, or straight violations, misrepresentations in advertising, across the financial sector. One thing I did want to step back and talk, when Elizabeth talked about disclosures, one of the things that we've also seen is not just whether the disclosure is clear and conspicuous on the page, but also placement of the page, how the consumer, when you're in internet advertising, how the consumer perceives that disclosure. So we will look. The FTC will look, the CFPB will look. Don't put your disclosures in such a way that you have to scroll up or scroll down, and that they're not, visible to the consumer. That's not a clear and conspicuous disclosure, and that's something I'm sure the FTC guidance will show you that as well.
Sure, and also the Consumer Financial Protection Bureau has been very active in that area too, in some of its prior enforcement activities, as well as also in its supervisory work. So there's really sort of almost no shortage of guidance out there, but being able to demonstrate good practices as an individual company or as an industry as a whole can be challenging. I've had the pleasure the last 6 months to work with the Leads Council on some of its work in both forward-facing to the states and on the federal side. Marty, you've been on the Lead Council board recently, working to both help the discussions with the group on self-regulation and maybe developing a self-regulatory structure to show good practices from bad practices, but also stuff related to external facing with the state AGs. Is that the type of work you think that can make a difference? Obviously, you're involved in it, so you must think it's going to help.
Yeah, I mean, sometimes there's confusion and maybe some misdirected animosity. I mean, you'll see people say ping post is bad, right? And if you haven't, if you look on your lanyards, I think the people that branded those lanyards have a saying, which is when lenders compete, consumers win. It's hard to have lenders compete unless you have some mechanism that they can compete. And so Leads Council, Rob, Greg is really trying to revive it, and Rob and Suzanne do a great job of pulling together materials to explain, well, let's think about ping post as a mechanism to get people to compete for your business. It's not per se terrible. Now you can't hide behind it and say, well, I only know one node in the network. I mean, again, you have to take responsibility for that downstream. But I think Leads Council can be a mechanism to pull materials together. It's educational. I mean, the FTC has always been willing to be educated. I've had good interaction with your colleagues. No CIDs yet. Yeah, Leads Council can be a great mechanism to, because we can pull different creative from people that are actually doing the work and put it together, quickly and explain to people why something takes place, and that leads to better understanding.
Joy, before we wrap up, final thoughts?
Again, don't advertise or sell leads for products that don't comply with the laws of the state in which you're advertising, and that, again, it's a 50-state view, but that's the work that you need to do. And do take reasonable steps to protect consumers' information. A little bit of thought about who you're selling the leads to and how the information is being used down the road can really avoid enforcement and make you sort of a more competitive marketer and protect and be compliant. Again, I think I just want to say that misrepresentations in advertising, keeping an honest financial marketplace are very much the mantra of our current superintendent, Vulo. So I think we're going to continue to be active in this space. We look forward to you developing best practices. We're here to talk about compliance. As you know, when we got out with our debt collection regs, we went out there, we want to see compliance. We're not looking to do enforcement. We do enforcement as necessary. So we're here. We have a lot posted on our website as well, and we're here to answer questions at any time as well.
Liz?
Well, I think pretty much Joy has summed it up really well. At the FTC, the focus is on what the consumer experience is. And as Joy brought up about, how you place your disclosures and things like that, I think is a good, short way of summing it up, which is we're going to look at all the venues in which you post information to consumers. So if you have a website that's accessible via a mobile device, then you should make sure that your disclosures are easily viewable on there. And like Joy said, you shouldn't have to scroll all over which way or shrink and expand or do anything like that. And I think it just really goes to the core message we try to espouse at the FTC, which is that the consumer should, while innovation continues to grow at a rapid pace, consumers should still have control of what happens with their data and who they choose to provide it to for the services that they choose to get provided to them. And so our aim is really to make sure that consumers are not kind of just being left behind and just taken for whatever their data is worth. And I think that just means that you have to be clear and conspicuous with what you're doing and know who your affiliates are.
Marty, as the industry member?
You know, I think it's funny that when you hear words like aggregator, it sounds like a bad thing. I mean, lead generation sounds like a bad thing. It sounds like you're kind of generating intent, where I think most of the people here are trying to manage intent to its kind of rightful destination. But I would say, you know, aggregators add value, and I think that one of the places you can add value is in kind of compliance aggregation. Because when you've invested in the people and the technology and so forth, you can acquit these responsibilities by being a point of aggregation, including for compliance. So I'm not sure it's always a bad thing to be an aggregator.
Well, with that, the final word from industry. We've heard today that lead generation can be a valuable service. It can help with competition. It can help with an informed marketplace. But we've also heard that there is government scrutiny, whether it be of information and data collection practices, as well as also representations made to consumers. But there is a path forward. There is ways that the industry can respond, either individually as companies, and build out compliance programs that meet or exceed expectations. In some cases, that may mean licensure or foregoing working in a particular market, in a particular state, if it's a licensable activity or an activity that is heavily regulated and may not be consistent with the business model overall. On the other hand, there's also ways, too, that the industry as a whole can work together, as Marty described, through Leads Council and other efforts. So with that wraps up our panel, a sit down with the regulators and industry. I'm Jonathan Pompan from the law firm Venable, and I thank you all very much for your time today. Thank Joy, Liz, and Marty for participating, and we look forward to doing this again at another LeadsCon. Thank you.
Thanks to everybody on the panel today. Hey, we're going to take one more quick break. 10 minutes from now, please come back and hear Tim Ash as he talks about the branding and direct marketing relationship, where there are ripples in that relationship and how you can smooth the water. Don't miss it. It's going to be really great. Thanks again to our panel today.